Hello, everybody. This is another special broadcast, and I will be quickly going over the DOJ's reply to Donald Trump's motion for an indefinite delay in the documents case. And as I summarized last time, Donald's reason for delaying indefinitely is that he's special. That's what it comes down to. And DOJ's reply to him in so many words is to say that no, no, Donald, you're not special. So I'm going to go over the reply. It's pretty straightforward, and it doesn't need. I don't think it'll take that long. So the government says that there's no basis in law or fact for proceeding in such an indeterminate and open ended fashion, as the defendants provide no other timeline. Defendants Trump and Nauta claim unequivocally that they cannot receive a fair trial prior to the conclusion of the next presidential election, urge the court to withdraw the current scheduling order, and request the court not even consider a new trial date until some unspecified later time. And to this, the DOJ says there is no basis in law or fact. And then the DOJ goes into its rationales. First, the applicable legal principle here is the Speedy Trial Act of 1974, which in pertinent part says, excuse me, in any case involving a defendant charged with an offense, the appropriate judicial officer at the earliest practicable time shall, after consultation with the counsel for the defendant and attorney for the government, set for trial on a day certain so as to assure a speedy trial. So the Speedy Trial Act is the statute, it's the law of the land, that there has to be a day certain, a certain trial date has to be set. A speedy trial is a foundational requirement of the Constitution of the United States, not a government preference that must be justified, referring to the Sixth Amendment right to speedy trial. The Act's manifest purpose is ensuring speedy trials, and any deviation from its 70-day benchmark must be justified. To be sure, the Act authorizes the court to exclude certain periods of delay from the speedy trial calculation, including any period of delay resulting from a continuance granted. And so there are exceptions to the speedy trial requirement, but they have to show that the people who are uh, asking for the delay from the speedy trial, they actually have to materially show why there is a deviance from it. And uh, but because the act was designed with the public interest firmly in mind, in order to exclude such a delay, a district court must find that the ends of justice served outweigh the best interests of the public and the defendant in a speedy trial. The public interest cannot be served, the Act recognizes, if defendants may opt out of the Act entirely, which the defendants effectively tried to do here by requesting an indefinite adjournment of the trial for a minimum of 15 months. So, this here, DOJ uses Supreme Court precedent from 2006 that says that the district court must find that the ends of justice served outweigh the best interest of the public and the defendant in a speedy trial, defendant's rights in a speedy trial. So, uh, what they are saying, what the DOJ is saying, that district court has to find that the ends of justice is served and it outweighs the best interest of the public and the defendant in a speedy trial. That's when the act would allow some sort of a continuance. Defendants' bases are urging the court to defer setting trial date boils down to alleged significant legal issues of first impression, the volume of discovery, the pendent SIPA process, the possibility that their dispositive motions might succeed, and alleged inability to select an impartial jury for trial. And the last one is their own schedules and those of their lawyers. None of them warrant the wide open schedule that defendants urge the court to adopt. First of all, the issues are not novel. Defendants cite two novel legal issues that they claim make it complex under the statute: the authority of the special counsel to bring and maintain this action, and the alleged intersection of the Presidential Records Act with the criminal statute charged in the indictment. In United States v. Nixon, the Supreme Court ruled that Congress gave Attorney General the power to appoint a special counsel. And the DC Circuit held that a special counsel appointed by the Attorney General has the authority to investigate and prosecute federal crimes. So United States v. Nixon is binding precedent on Aileen Cannon, meaning she has to follow the letter of the law from United States v. Nixon that says that the Supreme Court ruled that Congress gave the Attorney General the power to appoint special counsels. The PRA, and then we go to the PRA, the Presidential Records Act is not a criminal statute and in no way addresses the retention of national security information. Defendants are, of course, free to make whatever arguments they like for the dismissal of the indictment, and the government will respond promptly. But they should not be permitted to gesture at a baseless legal argument, call it novel, and then claim that the court will require an indefinite continuance in order to resolve it. It is unreasonable to expect adequate preparation for pretrial proceedings for the trial itself within the time limits established by this section. So that would happen if the court found them to be novel issues, this PRA thing and the special counsel thing. So the legal issues defendants raise do not justify deviation from the speedy trial date, much less an open-ended deferral of considering one. Because the Donald's motions have nothing of fact to show that a continuance or an indefinite continuance would be warranted. It pretty much boils down to I'm special, I'm busy, you know? Discovery does not warrant a continuance. We move on to discovery. Organized discovery the government has provided, will continue to provide in the near term, is entirely consistent with the trial date provided. Defendants have failed to include important information about the government's discovery productions. For the defendant's convenience, the government provided a discovery log, key documents of only 4,500 pages out of the 800,000 that we hear Donald Trump complaining about. The government similarly identified to the defendants the small subset of key CCTV footage. Defendant's characterization of the production as including 9 months of CCTV footage is misleading. The government obtained footage only from selected cameras, many of which do not continuously record, for selected dates throughout the period for which it obtained footage. They claim the reason is that all discovery materials are sensitive and high profile, but discovery materials are sensitive in any criminal case, and courts routinely enter the protective orders covering defense document reviewers. Magistrate Reinhardt entered such an order here with no opposition from the defendant. So this issue of sensitive materials being thrown around in Donald's motion and the 800 pages being voluminous and would take time is being countered here by the DOJ saying that we have specified and provided logs and arranged them in a way that would direct the defense's attention to the key documents that this indictment is talking about. But we have turned over much more than what the specifically relevant documents are. So there's that specificity that the DOJ goes to, is that they were from selected dates throughout a specified period of time, and they're not just vast amount of data that Donald's attorneys just have to now blindly wander through, because that's the impression that Donald's motion gives you. Then we go, the defendants also rely on the government's statement in its discovery letter that there will be additional productions of discovery related to some devices and search warrant returns. And note that the government has not produced all interview-related materials, including certain witness statements and associated memorializations. Did I say that wrong? I don't know. Of those statements. Defendants omit representations of the government's discovery letter about timing of the discovery that has been and will be provided. So the government made productions promptly following arraignment despite no obligation to do so. The government turned over Jenks Act material no later than morning of the first day of trial, but they have already been turning this material over. And the government has gone above and beyond to help the defense attorneys look at the pertinent documents upon which these indictments are based. In short, the government has promptly produced thorough discovery in an organized manner to include early production of Jenks Act materials. It also bears emphasis that the government has already sought a nearly 4-month continuance of trial, in part because of the need for both sides to review and process discovery. There is no discovery-related reason to further delay the jury selection in this case beyond December of 2023. Now we go on to the next. Classified information procedures do not justify a continuance. Indefinite continuance, because they lack classified discovery and because they contend the necessary procedures under CIPA are inherently complex. But in order to receive an interim clearance, counsel first needed to submit their relevant forms and supporting documentation to the litigation security group. As of this filing, only 2 counsels of record have completed this task. So while talking about how the procedures are complex, the DOJ here says they have not even followed through on the basic processes that the counsel, defendant's counsel should go through. We've given them this much time and we're giving them the processes, but they're not following through on them. The government's first tranche of classified discovery will include all documents with classification markings recovered from Mar-a-Lago to which Council's interim clearance will permit them access. The government intends to transport these materials early next week, set to the SCIF, Sensitive Compartmentalized Information Facility, maintained for clear defense attorneys at the Clyde Atkins Courthouse in Miami. Once defense counsels have their final clearances, the government will bring the remaining Mar-a-Lago documents. So, talking about the specific timeline that the government has provided the documents versus the aloof, indefinite, no specific time motion that Donald Trump has made, that motion clearly is an aberration from how jurisprudence works in America, which is in a timely manner. And so Aileen Cannon's decision is pretty clear here. You followed what the procedure is, what it has been, and you see how the DOJ has made special concessions despite everybody being equal under the eyes of the law, or Aileen Cannon can pull the same nonsense she did with the special master review and, in fact, not hold a definite timeline with a trial date when jury selection can start. So Aileen Cannon's work is cut out for her. The need for SEPA proceedings is also not a justification period for uncertain delay. It has to be case-specific circumstances requiring adjustments to the schedule. So the cases that Donald Trump provided, the United States versus Winner, and then there was United States versus Chaucan, each of them presented different circumstances than the one at stake here. And what the Chaucan one was because of the pandemic, and the Reality Winner one was where the council had almost 2 months to review initial production of classified discovery. So there's the timing of, they were given months of time because of certain reasons. And another case, now the DOJ comes up with other cases where in instances of cases under the Espionage Act, the cases, even with complicated discovery processes and with SEPA clearance proceedings, took less than a year between the arrest and the verdict. And in one, it was 9 months from the arrest to the verdict. So to say, give it an indefinite timeline because SEPA is complex is not reason enough either. Then the DOJ says in a catch-all that the rest of the defendants' remaining arguments are meritless. First, the prospect that motions might be fully dispositive, meaning pretrial motions might actually, end up trying the case, is not a factor under the Speedy Trial Act and for the court to consider in deciding whether to grant a continuance. So the court can't just say because this trial may be resolved in pretrial motions that we are not going to set a trial date, on that contingency that it might be fully dispositive. The defendants cite no case for their proposition, which is unsurprising because, again, they have it backward. So here's a little jab and I don't blame the DOJ because the DOJ has been dealing with this for nearly a year now. Don't forget the special master thing. The Speedy Trial Act requires the court to set a trial date. And the federal rules of criminal procedure key the filing of pretrial motions, including dispositive motions under Rule 12, relative to that trial date. So defendants would have it the other way around, however, requiring courts to assess the likelihood of a pretrial motion success before the motion is even filed in order to determine whether to set a trial date. So Donald Trump wants to turn it on its head, as I said previously. Our jury system relies on the court's authority to now DOJ is talking about the impartial jury part. Our jury system on the court's authority to craft a thorough and effective jury selection process, and on prospective jurors' ability and willingness to decide cases based on the evidence presented to them, guided by legal instructions from the court. To be sure, the government readily acknowledges that jury selection here may merit additional protocols, such as a questionnaire, and may be more time-consuming than in other cases, but those are reasons to start the process sooner rather than later. The only two cases the defendants cite on this subject do not help them. Both stand from the familiar proposition that in the wake of a particularly heinous or vicious crime that inflames the sentiment of the community, court can continue a trial or transfer it. So then DOJ goes through the examples of these cases, one of brutal murders, double murders, and says that in this case, that's not the situation. Moreover, the conditions that defendants argue will make it a challenge to select a jury will not appreciably change after the completion of the election. The government's position is that the best way to move in this case forward, consistent with the defendant's rights and the public's interest, is to set a trial date now with interim deadlines for the CEPA procedures and motion practice leading up to that date. Finally, the demands of defendants' professional schedules do not provide a basis to delay trial in this case. Many indicted defendants have demanding jobs that require a considerable amount of their time and energy or a significant amount of travel. The Speedy Trial Act contemplates no such factor as a basis for a continuance, and the court should not indulge in it here. Since a court schedule should not be subordinated by schedules of lawyers that appear before it. And this is a case that the court, that the DOJ brings up, that, the court system shouldn't become subordinate to the lawyers' schedules. This, and another court says, another case ruling, this court deems defendants' counsel pre-existing trial schedule insufficient justification for granting a continuance in this case. So, with all these said reasons, Jack Smith respectfully submits that there be a December 11th trial date set, and then we move according to that trial date with specific dates for the CEPA procedures and other proceedings, and when the discovery is going to be. So that's the response. Hi, everybody. Derek, hey, Zoila. Hi, Deb. Thank you for being here, all of you. So this is pretty much a cutthroat, self-explanatory, response to Donald Trump's really out of the blue, completely nonsensical, I'm special, I'm busy sort of argument, and I'll say it again really quickly. If Aileen Cannon were to follow stare decisis in ways that trial process goes on, if she is to adhere to the Speedy Trial Act, she will set a trial date and she will deny the part of Donald's motion that says that leave the trial date open. If she, however, deviates from the norm and does something like she did with the special master review, then she is likely to grant this indefinite thing. And when she grants this indefinite loose, uh, no set trial date because of whatever, because she agrees with Donald's argument, that I believe will be an appealable order for Jack Smith to take to the 11th Circuit to say that look at this ruling, which really goes against every other case, much like the special master went against every other case that is in precedent. Please order recusal of Aileen Cannon. So, this is a make or break for Aileen Cannon as well, because if she rules in Donald's favor, it gives Jack Smith an appealable order to take to the 11th Circuit and move for Aileen Cannon's removal from this case. And if she grants the DOJ's December trial date as a tentative trial date, then she will still be in the game of being the judge overseeing this case. So the choice is up to Aileen Cannon of whether she wants to do something that would kick her out of the case or whether she wants to stay in the case. And that only Aileen Cannon's ruling will tell. And when that happens, I'll get back to you guys. So, any questions? Lovely people, and I love that y'all are interacting. If there are no questions, I will end this live stream. Thank you so much for everybody who's here. 5 of you. If you're new, please subscribe, like, comment, share. It really helps me out with my algorithms. I have no idea what algorithms are, but if you like and subscribe and share, then more people will see it. Is kind of what I have been able to surmise from it. So thank you, and we'll see you soon. Take care.